What is probate anyway? My name is Philip Bruce. I am an estate planning attorney here in Minnesota, and a frequent topic of discussion, what is this whole probate thing? I had a client come up and she was a little surprised to find out that there's really three types of probates. There's three ways to go through the probate court system. Probate is the administrative court proceeding where if I die, my stuff has to get divided up. If we don't have any legal documents, we're going to use Minnesota's backup rules. They're called the intestacy statutes, but don't worry about that. If we have a will, we're going to use the will instead. Wills are great because they control probate. Common misconception, I've covered it before. Wills don't skip probate. They require probate to work. They're a court document that tells the court what to do. That is what a will is. And if we're going to go through probate, we're going to use this thing to tell us who's in charge, where does the money go, what are the backups, in what order are things distributed, do people get it right away, or do they got to wait till they're a certain age, etc. We can be very, very specific or very general with them. Three levels of probate. The first one is called an informal probate. Every county in Minnesota has different rules for what an informal probate is going to look like, but the big hallmark is it can be done over the mail. There's no court hearing. And because we don't have to get on the court calendar, it typically ends up being faster and cheaper. There's disadvantages. You're not going to get any court order that excuses the executor from liability. There's not going to be any dispute resolution or orders saying this is what happens, this is what happens. It's literally, here's your authorization to sell the house. That's it. They're good in certain circumstances. The next level, and the most common level, is called a formal probate. Some counties require a formal probate anytime there's real estate, for example. And in a formal hearing, a formal probate is typically going to require at least one court hearing, sometimes two. And what they're going to do is have a lawyer show up with the executor, with the will, and they're going to say, okay, this person has been appointed. Do you understand your job? Here's what the assets look like. And the judge is going to sign off and say, okay, you are hereby appointed. And then at the end, we might have some court orders and some other things that go with that. We can excuse the executor from personal liability a little better. And these just are a little more organized, but they're more expensive than an informal probate. Lastly, is a formal supervised probate. A formal supervised probate is kind of the bad probate. This is the probate where something's going on and a judge has to supervise the distribution of everything. These things get crazy expensive. There's usually many beneficiaries. Sometimes there's ambiguities in the document. A lot of times someone did a do-it-yourself will, which is never a good idea. So that always requires interpretation, or there was a will and there was a will that was sort of half completed but not signed properly. Any of these things can trigger a formal supervised probate. At any rate, probate can be something people don't want to go through at all. There's an alternative tool called a revocable trust or a living trust, which skips the whole thing. Happy to chat about that. If you have any questions, give our office a call or shoot us an email.